first thing I'll do is a roll call just so the record can be clear and we'll know who's here and who we're waiting for. But we'll get started. So welcome everyone. Good to see you again. And I know it's been a while since we got together, almost a year now. Some of that due to the pandemic that's changed the way we do things. So we're having this meeting via Teams as opposed to in person as we normally would. But I think it's all going to work out well. So first thing I'd like to do is a roll call just to see who we have here. If you could mute your microphone when you're not talking, it would make things a lot easier and let us better be able to hear each other with no background noise. So we'll start with Justice Ecker.
Good afternoon. I'm here. I don't know. Is my microphone working?
Yes.
Great.
Only I know how much difficulty you have with the mute button.
That's right. Well, I got a strange message on my machine, something about my microphone, and I wanted to make sure it was working. But hello to everyone.
Hello, we got you. Judge Goodrow.
Yes.
Judge Youngblood.
I'm here. Can you hear me?
Yes, we can hear you.
Hello.
Hi. Judge Morgan. Looks like she's here, but she did mention she might be late. So we'll go to Judge Sheldon. No. Judge Prescott.
I am here.
How are you?
I'm well, thank you.
Attorney Edelman.
Here. Good afternoon, everybody.
Afternoon. Attorney Brookman.
I'm here. Good afternoon.
Attorney Costello.
I'm here.
Attorney Gaylor.
Hello, everybody.
Attorney Goulash.
Hello, everyone. I am here.
Attorney Massicott.
Hi, I'm here.
And Attorney Steigelfest.
Present, Your Honor.
Okay, I think we have almost everyone except Judge Sheldon and Judge Morgan, which is great. Okay, I think they may be joining us later. So the first order of business is approval of the minutes from our last meeting. Is there a motion to approve the minutes?
So moved. Mike Gaylor.
Thank you.
I'll second the motion.
Thank you. Okay. Any discussion? Seeing none, I think the minutes from the last meeting can be approved. So I think everyone received the agenda, and what I wanted to try to do is kind of provide an overview of where we were, where we are, and where I think we are headed, at least for the rest of this year and a good part of next year. We had, prior to us breaking for our last meeting, we had approved a couple of minor changes to the commentary for sections 9.1 and 9.3, and we were holding those since they were smaller edits for the bigger undertaking with respect to the business records and the admissibility of business record and authentication of it without a live witness. We appointed the working group to look into that, and despite the long absence due to the pandemic, the working group has been working hard and submitted to us their proposals for what to do with 3 sections in particular, and creating a new section of the code. So we'll discuss that, and if if we agree with the proposals, or there's not much heavy lifting to do to amend or change them, we could agree that we recommend those proposals in addition to the two smaller ones to the Supreme Court for the Supreme Court to review and approve, and then get it out to the public, probably electronically, before we come up with a new revised book, code book. I do want to mention that we also talked a little bit about Public Act 1916 in our last meeting, and we tabled that discussion. In my view, it may be a little much to bite off to chew that particular section in this meeting, but I would like to have another meeting in shorter order, probably early January, to discuss 1916. I know Lori just sent out the actual Public Act to everyone this morning, and I wanted to give everyone enough time to look at it and get your mind back into that, as opposed to trying to jam the business record sections and that into one meeting. I don't think we'll lose much time if we focus on the business records today and then have another meeting within a month or so to deal specifically with 1916 and how we're going to do it. If anyone remembers, I think part of the issue was we were discussing whether to adopt just the statute as is. Another issue was where to put it in the code, or if we needed to take some things out of it to put it into the code. And so some of those things are the things I think we should think about and be ready to discuss in our next meeting. And then, consistent with what we've been doing, I think we could present all of that to the Supreme Court, hopefully in February, March of next year, and then get these sections approved and out for public comment, and then into the code. So I think that's where I see things going. Certainly, if people have other ideas, you can let me know. But that would wrap up the work the subcommittee's been doing, the work we did to amend 9.1 and 9.3 and incorporate 1916 and get one big package to the Supreme Court for the Supreme Court to review. So with that said, I think we can move right into the main item of the agenda, which is the report from the subcommittee or the working group that worked on the sections 1-1, 1-3, and 9.3A, the new section. So with that, I'll turn it over to Justice Ecker.
Great, thank you. So what I'm going to try and do is provide an overview of the rule change and where it came from, sort of what its purpose is, without getting into too much sort of down into the weeds, to provide the context that's useful without taking too long. However, I should say, the devil is always in the details, and so it's certainly the work of this committee to look at it in detail, and no detail is too small for anyone to raise. So I'll just go through an overview, as I said, and then it may be that after I'm done, that if anybody on the working group wants to add 2 cents, cover anything I missed, or correct any mistake I made, that would be useful. The working group consisted of Judges Prescott and Morgan, Professor Simon Kerr, and then we also had the attorneys on the committee were Mike Gaylor and Kim Massicott. The group did a lot of work over the years. We sort of, this year hit us hard, I think. We sort of slowed down a little bit. But a lot of the work was already done. We had a very important meeting in March, just before COVID hit. And then after that, we followed up with a lot of drafts going back and forth. I think the recommendation we ended up with is one that's supported by all members of the working group. if anybody has any comments to make or reservations, I want to make sure they have an opportunity to do that. The origin of the thing, and I'll only point this out to highlight what we didn't do. But the origin really went back all the way to a letter or email that we received from Attorney John Tower back in 2017. That got put on hold for like a year or more, maybe a year and a half, I think, because it came in right when we were doing all those changes that resulted in the 2018 revision, and it was too late for inclusion, and so it was sort of put on hold and then got taken up at the end of 2018. I think most of the work got done in 2019 and this year. So Attorney Tower really focused on a whole bunch of things, both the ease of the rules or loosening of the rules for admissibility for public records, as well as for business records, as well as public records. And he had a bunch of other things on hearsay rules that he commented on. We ended up focusing really on two issues. One was the business records and one was public records, and ended up at the end focusing solely on business records for reasons I'll explain in a minute. I point that out because the work that we didn't do on public records potentially has yet to be done. That'll be a question for the chair of the committee and the rest of the committee, I suppose, as he deems appropriate. But, I guess I'll say this. The overall idea here was to look into easing admissibility rules, making it more efficient or streamlined to get business records and public records into evidence, primarily authentication issues. We ran into some bumps with respect to public records for numerous reasons, but a couple of which had to do with the fact that there's some statutes out there. I think 1-14, and then I forget if it's 1-10 or 1-12, but one of the provisions of the FOIA that made things a little more difficult, particularly with respect, or at least controversial, with respect to the substance. It wasn't really an authentication issue. It had more to do with the substance of the records and suggestions in some statutes that the records would be prima facie evidence of the contents thereof, which could create a problem with respect to public records when there's reports with multiple levels of hearsay in a public record, for example. To what extent do those statutes make the substance of the evidence contained therein admissible? So we put that on hold. There's other reasons too. There's databases now, or rather websites with public records. So it's a lot more extensive than birth certificates, death certificates, and things like that. And so the question of how to deal with evidence on public websites and public records generally, we just thought was a little bit biting off a little bit more than we could chew, to use a useful metaphor. So that's put on hold, and again, that's sort of an issue maybe for another day. But I wanted to note it because it's not like we dismissed the issue as not unworthy of further investigation. To the contrary, it may be something worth looking into. But as to business records, the question quickly became, well, is there a need to change the rules so that it's not necessary to bring in a live witness to authenticate business records for admissibility purposes? We looked, and Lori, I should say, I neglected to say this, so let me say it right now. Lori has done an unbelievable job helping us all every step of the way, and she did, among many other things, I think, Laura, you were primarily, was it, did Kim help, or I know Kim did other work, but you did the 50-state survey yourself. Is that, or
Yeah, that I was the survey person.
Yeah. I mean, a lot of work. So we did Lori did a 50-state survey looking at how other jurisdictions and how other states did it. There's a federal rule that deals 902 that deals with essentially self-authentication of business records. We looked at that, and it turns out that a lot of other states, I think all or most other jurisdictions permit this evidence to come in through a certificate or an affidavit of the entrant of the keeper of the records, certifying to certain foundational issues. So, the question was, should we do that? And I guess this is the answer. We are recommending that it be adopted, or that such a rule be adopted. It was put into the form of 9-3 A, which you'll see. I guess the only other thing I'd say is, in terms of that question of, is it needed? The commentary sort of addresses that, and that may be a useful place to look. Look, it's possible for parties, and they often do. I know in civil cases, and I assume in criminal cases as well, just stipulate to the admissibility of these things. So the question is, what's the problem? And I guess, the fact that every other state has done it might indicate it's a good idea to have an alternative means other than through stipulation. Sometimes I certainly had plenty of cases where, one lawyer or the other, I hope it wasn't me too often or at all, but some lawyers just can't agree on anything. And sometimes it's because they're unreasonable. And sometimes it's because they just have clients who say, look, we're not doing stipulations or whatever. So there may be, impediments to stipulation, but nonetheless, no really substantive issues about the authenticity of these business records. That can be an issue. It can be inefficient. To the extent that there's not, any substantial issue about the authenticity of a document, it's one of the great hassles of being a lawyer to have to work through all that rather than be able to get the thing in by an affidavit. So we addressed that. The biggest issue really we confronted was the question of, can it be done under the existing rules? That led us, I won't take you through the nitty-gritty of that one, but that took us back to 1-1 and 1-3. And really the reasons for these changes that you see in 1-1 and 1-3 are because as we went through those rules, and Judge Prescott insisted that if we just would read the rule, it would give us the path and tell us that we could do this anyway. We saw, and I think Judge Prescott himself, I'll let him speak for himself, but came to see as well that those rules were not the model of clarity, let's just say, and could really use some help and clarification. And I would say more than anyone, probably, that he and Professor Simon Kerr worked on some of the detailed language, particularly in 1-3, 1-1. You'll see there was a minor change there, but in 1-3, both in the text and the commentary, to clarify what those rules did and didn't do with respect to preliminary questions, and really how 1-3B worked. That it was a rule of relevance, about relevance, that's pretty much all the changes on that. And again, I would offer any of the members of the working group, but certainly Professor Simon Kerr and Judge Prescott, who may be able to answer if there's particular questions about why you did this or did that, or changed this or that in the rule or commentary to 1-3. But it all ended up being a result of examining those rules and asking, with precision, sort of what they allowed, didn't allow with respect to just how it works. And we were looking at it through the lens of using an affidavit to establish the preliminary facts to allow for a document to come in without compliance with the authentication rules. But we ended up, I think, more broadly looking at the way that those rules were written. So I could go on, but I probably, at the risk of confusing rather than clarifying, I won't go on about what those particular changes were about. You'll see that the authentication is really sort of a special case under 1(3) sub B, and we treated it like that and tried to explain what was going on there. Ultimately, the fact finder is the ultimate decider, I guess, to quote George Bush, of whether a document is authentic or not. And so the trial court makes the initial determination of admissibility on a prima facie showing, but the ultimate determination is up to the finder of fact, the jury, let's say. That's the reason why, if the affidavit comes in, if authentication is done through an affidavit, the affidavit comes into evidence for the jury to ultimately, I guess, assess. So with that, hopefully that provides a little bit of an overview. I think before opening up things, with your permission, Justice Mullins, I just wanted to give any other members of the working group the opportunity to chime in, because I'm sure I either missed something or confused something or something else. I don't know if Judge Prescott, Professor Simon Kerr, or anybody else wants to say anything.
Sure.
Yeah, the only thing that I would add to, I think, Justice Ecker's excellent kind of description of where we are and how we got here is if you recall in some prior meetings, I had raised the point that under 1-1D2, that provision specifically says the code does not apply to the trial court making certain preliminary determinations regarding the admissibility of evidence. So if you think about, for example, the excited utterance rule, the factual predicate for something coming in under the excited utterance rules requires some preliminary determinations of fact by the trial court. And as I've read the code, and I think as the code was intended, the code doesn't apply to that kind of mini proceeding or that determination within the greater trial. And if the code doesn't apply, then the predicates that need to be established in the trial court's mind for the admissibility of the utterance can be proven by things that would not otherwise be admissible under the code, including hearsay itself. So one of the early questions we raised was, well, why doesn't that apply to business records? That you could use an affidavit simply to lay the foundation under the business record exception to the hearsay rule for the facts that you needed to establish to get it admitted under the business record exception. And I think what we came to eventually was an understanding that while an affidavit might get it done with respect to the factual predicates necessary under the specific code provision for business records, it didn't solve the problem of authenticating those records, because the evidence used to authenticate the records has to be in an admissible form, because as Justice Ecker explained, that's ultimately a question for the trier of fact and not the court as the gatekeeper who's simply making a preliminary determination about whether or not a sufficient prima facie showing has been made. So while 1-D2 solves a lot of problems in terms of getting evidence in through the use of affidavits to lay those factual predicates. It didn't solve the problem entirely, and that's why we've done it the way we've done it.
Lori, did you want to? I'm sorry, Julia. Did you want to say anything? Not that you should, but you know, I just want to make sure that since you had such an important role in the drafting, that you had an opportunity to say something if you wanted to.
I think you've both covered it as well as, yeah, you've said everything I would say, so I won't duplicate it, but I'm happy to help answer questions that people may have.
Does anyone have thoughts or questions, concerns?
You know, I would say not to promote discussion necessarily, if there isn't any, but some of this is going to have to go hand in hand with rule changes, I would think. Whether, I don't know, you know, whether it would be rule changes or some kind of standing orders or something about the way in which notice and opportunity to contest is provided. I think again, I don't know in the criminal context, but for civil, in the civil side, you know, that could arguably, you know, how much time do you have to give the other side? And what's the sort of mechanism for that? I think it would get, I think it will get integrated. I mean, I don't know, Judge Prescott, Judge Morgan, and maybe Judge Youngblood, although mostly, I mean, this is mostly on the civil side. I'm wondering, you know, I think that I think it'll get integrated into the civil rules pretty easily, but I don't know. And I don't know if anybody has concerns about that or anything else. We tried to leave it pretty vague in the commentary. But I mean, do people think that this, is a general idea that this is going to be a benefit to bench and bar? I guess is the question.
Steve, I have a question if I could ask. I could be overthinking this. So the court is making a decision on whether or not, in essence, the document can go to the jury, right?
Yeah. I mean, I think as in any authentication, you know, proceeding, if any issue, right? The court makes that initial determination, assuming there's an objection, you know.
And the court can make that decision based on evidence that would not otherwise be admissible under the code, like hearsay, right? Or am I wrong? Elliot's saying no. That's the piece I'm missing. So
the factual predicates of the hearsay rule, the kind of things that you need to, putting aside authentication, you know, that was made in the regular course of business, and those types of determinations can be satisfied in the judge's mind through the introduction of hearsay evidence that would otherwise not be admissible in the proceeding. Mm-hmm. Putting that aside, when you talk about authentication, the judge has to make a determination, not whether to credit the evidence that relates to authentication, but just whether or not the proponent of the evidence has made a sufficient prima facie showing that the evidence is what it purports to be. The evidence needed to do that needs to be in an admissible form, because the jury, let's assume that it's a jury case, because the jury is the one that's still going to decide whether or not the evidence is what it purports to be. The jury, unlike the trial judge, can say, I don't believe the testimony of that witness who said that the photograph was taken on or around the time of the event at question. So the criteria for whether or not it meets the business record exception to the hearsay rule, that can be in an inadmissible form, but we needed to find a way to get the authentication evidence to the jury in an admissible form. And that's what 9-3A does, which makes admissible an affidavit that otherwise wouldn't be admissible in the proceeding.
Understood. I'm just thinking about it from the perspective of an attorney who might object to that process. That's all. Thank you.
I have a question, if I might. Is it the intent of 9-3 that the certification is itself prima facie evidence sufficient to get the records in? Or does there remain a decision for the trial court to make if there's an objection and evidence as to admissibility on the question of whether they are in fact business records? My question is, if a group of records are accompanied by a certification that they're in compliance with the form, but the other side objects and takes a deposition, and it's pretty clear from the testimony that's elicited that at least some of those documents are not in fact business records or wouldn't satisfy the criteria. Is the court without power to prohibit the introduction of those things because a certification exists?
There's two questions. One is the intent, and then the other is what the rule says. I think that the intention here was to, under 9-3A sub B, was to essentially say, look, the burden would be on the party opposing or objecting to admissibility, but that the court would have the responsibility to determine, based upon the objection, whether that threshold showing has been made. In other words, it's not automatic. You submit a certification and it doesn't automatically then, it's not automatically admissible. It just satisfies the, a threshold showing in the same way that if the idea is that it would be serve the same function, I think, and correct me if I'm wrong, members of the working group, please. It's the certification serves the same function as if there was a witness on the stand saying those words. Still subject to being, disproven, if you will, by the objecting party. Which is why that notification process and that preliminary process, Jack, is so important, right? I mean, a party has to see the records and see the certification and have an opportunity to develop the evidence that they might want to put on to contest it, by asking the right questions at deposition or whatever. I don't know. Does anybody want to add anything? And I guess there's a question of whether is the rule clear enough on that, Jack, or do you see a problem there if it's not clear?
Well, I wasn't certain what it meant because subsection A says that the requirement may be satisfied by a sworn certification, and I took that to mean that it can also be satisfied in other ways, but not entirely clear whether it also meant that certification doesn't necessarily satisfy the requirements. Clearly that's in the commentary that there are alternate approaches to it. But when you start to talk about prima facie evidence and you have a certification that says what it says, it wasn't entirely clear to me whether it was the intention that the certification means it's going to come in and the rest of it is all for the jury.
could I just ask if, when people speak, could you just identify yourself so we know who's talking? Because I don't think everyone's picture is on the screen, so we can't see everyone.
I apologize for that. It's Jack Steigelfest.
No problem. No problem. Thank you.
This is Bob Edelman. I think Jack's concern is really addressed with the word may, but in addition, the last clause of subsection C, which says that the adverse party with a fair opportunity to challenge, it would seem to me that that says the judge can say, no, I don't think the certificate is any good, because otherwise, why would you give the ability to challenge it?
Yeah, so just to give this is Judge Prescott, just to give a particular example, let's say the affidavit that the proponent of the records says that these are the business records of XYZ Corporation, and the certificate is signed, or the affidavit signed by someone who works for an entirely different corporation, and it's not their records. The judge wouldn't have to let that go in. The judge can make a determination upon an appropriate challenge that for example, this affiant doesn't have the personal knowledge, or it's not their business records. All of those challenges you would still have a right to make.
I have a question. Anyone, and particularly the working group, but for a business record specifically, though, if you submitted a certification that did satisfy, you're not saying this is the record of a company and you're an entirely different company. You satisfy sort of the building blocks in the prima facie case. Wouldn't and the affidavit could come in. Doesn't it automatically become authenticated in that scenario? Like what would the judge do? How would that not go to the jury and be considered both satisfactory certification and authenticated?
I mean, I think it would. Normally, if there's an objection, as we're hearing now in the public sector about election fraud, there would have to be some proffer by the objecting party about as to a basis for rejecting. So it would have to be either there would have to be some evidence that the certification, which on its face satisfies the requirements of 9.3a, is untrue or inaccurate. Right. And I assume they'd have to do that by either deposing, deposing the person giving the certification or subpoenaing them in and saying, hey, you say you're the president of XYZ, but according to the records of the Secretary of State, that you're not. It's whatever the case may be. I think absent, but so absent evidence that the certification on its face does automatically get it in, I think, if it's in proper form.
But of course, Justice Mullins, the jury always is going to retain the ultimate right to make a determination, including that they just simply don't believe that the evidence is what it purports to be.
Right. Yeah, no, that's important, yep. Critical, important point. So ultimately, the certification is just supposed to be a in lieu of or a substitute for that live witness. I guess we'll just have to see, assuming we adopt this, how useful it is, how often it's used, and that kind of thing. I'm given some comfort by the fact that the federal rules in every other state seems to have thought that this was a good idea. But I don't know. I mean, the trial court and Judge Goodrow, I'm sorry, I left you out. It's part of the perils of dealing with the video conference format. But the trial judges and the trial lawyers, I guess, will be the ones who will, in the end of the day, have to tell us whether this is useful. Saves time.
This is Bob Edelman again. I can answer that. It's useful. I mean, the context that we most often see a principled defense lawyer not agreeing to the admissibility of a business record is a police report. And the difficulties of getting a police officer into the courthouse and to the witness stand and he's not even the guy who wrote the report. He's just some guy from the records division. And again, a client says to the lawyer, I don't want that police report in. It is of significant practical value that the opponent of the police report, whether it be the plaintiff or the defendant, I mean, might be the opposite, might be that the plaintiff doesn't want that police report in. Would have to come in and make a showing. This really isn't an accurate copy of the police report on file. That is very valuable. And again, as Justice Prescott said, that's just the first question. That doesn't mean all the police report goes in, and it doesn't mean that the jury has to accept what's in it. But at least it gets you through that first step without calling that guy from the records division.
I have a quick question. It's Karen Goodrow. Is there anything about subsection B that intends to preclude the court on its own from finding that the certificate is not valid? I'm thinking with self-represented parties who might not know any better. So that there's not some, let's infer for a minute it's a family case with two self-represented parties. If there's no objection by an opposing party, I'm inferring this doesn't preclude the court on its own from raising the question, or am I wrong about that?
Karen, this is Lisa Morgan. If I can respond.
Lisa.
How are you? Sorry I was late to the meeting. I think the answer to your question is there's nothing precluding that because subsection A says may be satisfied. So if you have the plaintiff who has filed an affidavit that says, this is my credit card bill, it's a business record because it came from a business and it was sent to me, and it's based upon my own information because I know that these are the charges that my wife made, etc., that doesn't comply. So it may be it's not an automatically is admissible. So. And then to follow up on Bob Edelman's comment, I also think it's helpful in that same context that you're discussing, Karen, because oftentimes I would find in family court that when the issue was raised that you're not going to be able to get certain business records into evidence unless you have someone there to testify, the choice was then they would just completely eliminate that portion of the evidence. They wouldn't try to get someone to come in and testify because it was too cost and time prohibitive to do it. And I think now by giving the opportunity to do this by affidavit, you might actually get the evidence that you need in some cases where otherwise it would have just been precluded because of a lack of a live body.
Thank you. Thanks, Lisa.
Can you hear me? This is Mike Sheldon.
Yes, we can hear you, Mike.
I do have a question. The idea here of admitting the certification, I take it is so that the jury has a basis upon which to understand whether that which is certified to is true and that which is presented is accurate, is in fact the document it purports to be. Is that right?
Yeah.
If that's true, then why isn't there another requirement for the certificate that the thing that qualifies the witness to be a qualifying witness is presented? Otherwise, if it's a custodian of the record, I'm sure that would be something somebody would avert to. But if there's supposedly somebody who has some other qualification to be the witness, that is arguably where some of these problems lie about being an officer of a different corporation or not really having access to the information. Why isn't there a requirement that the certification contain what amounts to the bona fides of the person giving the certificate, in addition to the stuff that he's talking about? Because otherwise, because this is a preliminary determination that the court would make, the court might know that information, but there would be no particular reason why the fact finder would know it, because it would not come in along with the certificate.
So the question goes to the identity of the affiant and the basis for the affiant's statements.
Qualifications. Right. What's the basis upon which the person offers that knowledge and acquires the status of being another qualified witness? Because if it's not the custodian, which is obvious, right, but it's somebody else, then the facts upon which that individual's knowledge, to the point that it can be relied upon for all the information in the certificate, will not necessarily be before the jury. It may have come before the judge in admitting it, but I don't see anything here that would allow that to come in before the jury.
I mean, sub A talks about that it has to be satisfied by the sworn certification of the custodian of the record or other qualified witness. So I guess you could say implicit in that is that the person that the affidavit would or certification would establish their status as such. I don't see any reason why we couldn't make that an explicit requirement. I don't want to speak on behalf of the other members of the working group. Anybody else have any thoughts on that?
This is Professor Simon Kerr. I agree that I think it is implicit in that other qualified witness. I would imagine that whatever that person would need to lay out their qualifications in the document as well, potentially, if they're not the custodian of the records, but we could make it explicit. I don't remember seeing any, having read Lori's 50-state survey, I don't remember seeing examples in which other codes were requiring that explicitly, but that doesn't mean that we couldn't do it.
What comes to mind, this is Mike Sheldon again, what comes to mind is there are a number of these cases, and I don't mean to comment on anything that's pending because I wouldn't know it's pending, but the countrywide cases where you have people who receive documents from other people who get documents, and then they certify to the contents of somebody else's documents because they've received them in some kind of a data drop, along with hundreds of other things that they've bought all at one time. And it seems to me there's significant questions raised about the bona fides of those people, and yet frequently that will be offered as the basis for receiving evidence by way of affidavit, and it's in a different setting. And I just think that can be avoided by the simple expedient of the person establishing the basis upon which he purports to claim knowledge of the other matter in the affidavit, the certification, I should say.
Mike, can I ask a question? This is Lisa Morgan again. Is your question whether or not just the business records themselves come in, or whether the certification plus the business records come in?
This has to do with the certification. Okay. If the certification is going to come in without anything to identify what the basis is upon which the certifier acquires his special knowledge.
But then, if the certification said, my name is Joe Smith and I am the record keeper for company ABC, and I'm responsible for maintaining the records of the company, and then subsection 1, 2, 3, essentially, is that sufficient? You just want some background on who the affiant is?
Right. I think that the affiant would have to specify what the other basis is, because I'm not worried about those who are or who represent themselves to be custodians of the record, but rather those who purport to be other qualified witnesses. Mm-hmm. And it seems to me that as long as there's that sort of escape valve for other qualified witnesses, then whatever their qualifications are or purport to be ought to be known to those who will argue as to whether this thing should be accepted and relied upon in substance, which is the job of the trier of fact. So I just think that ought to be part of it if the certification is going to be admitted. If it's not going to be admitted, then obviously it would have to be something otherwise presented to the court, and it would remain merely a preliminary determination as to admissibility. But this year's something that's being proposed as evidence to go to a fact finder. And if that's the case, then part of the basis upon which you validate that stuff is what the person's ability is to be a custodian or another qualified witness. It ought to be in the affidavit or the certification.
It's Bob Galash, if I could just jump in for a second. It's very difficult for me to imagine that there's any downside to what Judge Sheldon is proposing. It doesn't seem that there would be nothing confusing about it. And I think it could only add just enough more substance to that which the fact finder will ultimately be reviewing as part of the process. So I can't see any downside to that additional, I'll say, additional information as part of the certification.
The only downside I see, I mean, I don't disagree. The only downside I see is that in crafting the language that we would be understood to be imposing sort of additional requirements or give people a foothold for arguing that there are additional requirements beyond the requirement that the person is the keeper of the records. I mean, because we might have to get into a definition of what is it that qualifies the witness? You know, the qualification. And that's part of the dispute over 52.1, as I understand, over the business records rule is what is it? It's a particular, you know, usually you have to give an affidavit based on not personal knowledge and belief. Business records are a little tricky because the person who's certifying or attesting to them as business records does not have to have it can be a person off the street, as I understand it. It doesn't have to be a person with personal knowledge of the, at least of the underlying transactions. So it's a little tricky, I think, under the business records rule itself. But if we can avoid making it more complicated, I mean, this is just in response to your point, Bob, what's the harm? You know, there's always harm. Take it from me as an expert, there's always harm in saying more. That would be my only concern here. We'd have to craft the language so as not to create additional requirements that are unintended.
I'm just looking at the 50-state survey again, and it looks like California has in their rule, they say the first thing in the certification is that the affiant is the duly authorized custodian of the records or other qualified witness and has authority to certify the records, which seems suitably vague. But maybe, or that might be a way to skirt that problem.
Julia, this is Lori. I think we were both flipping through at the same time, and New York uses the same language which you just mentioned, so it may be something that's done quite often.
Yeah, I guess then there's a question of whether it can be, I think just speaking to the chair, Justice Mullins, you know, this is if this is something that seems to have a consensus view, I don't know, you know, a consensus behind it. I think it's something that can be done, without great difficulty. I don't know if there's any objections. Haven't heard from any yet, but whether it would be part of the rule or in the commentary, I guess is another question. It is a subsidiary requirement in the sense that it's about the qualifications of the witness more than the content of the authentication itself. But that could be. I think we could work that out, and if we're going to have another meeting soon, I don't see any reason we couldn't take this up and make a proposal over the next month or so. But again, I don't want to, if there's a valid objection to Judge Sheldon's point, and there often is, that's a joke. But no, if there's a valid objection, then I don't want to cut anybody short on that.
Does anyone have an objection or another view?
This is Bob Edelman again. I don't have an objection at all, but Steve said at the beginning that this is going to probably be coordinated, I would assume, with the practice book and the rules committee. It would seem to me that there's going to be like a form certificate or affidavit, and that language could be incorporated in that rule as opposed to complicating the code rule.
This is Lisa Morgan again. My only concern with that is that if the Civil Rules Committee is going to adopt this rule, I would be concerned that they wouldn't see fit to add a provision that we didn't agree to add. So if we all agree it should be in there, and I've looked through too, as the others did, it's in Texas's rules too, and it simply is that the affiant's duly authorized. The affiant is the duly authorized custodian of the records or other qualified witness. And then that leads up, anyone who wants to challenge whether or not you're a qualified witness will now have the ability to do that because you've attested to it. So I think we can leave it very broad like that. And once you have that as part of the affidavit and then the other three provisions, then the issue as to whether or not the custodian or the qualified witness is truly qualified is subject to attack again under subsection C.
So that would probably be 93A A1, and then move 1 to 2 and 2 to 3 and 3 to 4. Yeah. Right. So just to have that the affiant is fill in the blank. We could draft that up.
That sounds like a plan. So the working group will draft that up, and then we could take that. We could see what it looks like, and then discuss it at our next meeting, which will be sooner rather than later. Are there any other concerns or thoughts people have about 9.3A?
Justice Acker, I don't think, I'd have to check with our Director of Legal Services with Joe Del Campo, but if this were to be an official form, it doesn't necessarily have to be vetted by the Rules Committee. There's a subset of forms in the practice book that are in the appendices to the practice book, and those are voted on and approved by the Rules Committee. But there's scores of other forms that are official judicial branch forms are used, for all sorts of procedures. And they go through the legal services channels and are, approved by the various divisions and court operations, but they're not presented in front of the Rules Committee for approval. So subject to Joe Del Campo's advice on that, I don't think this is necessarily anything that would need to be coordinated with the Rules Committee.
I guess the idea here is just to put it right into the rule so that whoever makes a form, if there is a form, knows what to put in it, and what language to use.
Yeah, I actually think I'd probably be the person making the form. So.
Well, Lori, I intend to talk to Justice McDonald after this call, and maybe you could be on it with me, and we'll just hash it out and see which is the best way to go.
Yeah, sure. That sounds great.
Okay. All right. Well, if any other concerns of 9.3A? If not, does everyone, I guess in general, agree with 9.3A, subject to the changes that we're going to make? But does everyone agree to add this new section?
Yes.
Okay.
Yes.
This is Judge Youngblood, Barbara Youngblood. I do agree with it. I commend you guys for your work on this, the work group. I think it really does have the potential to be a benefit. And I think with the addition that Judge Sheldon is recommending, it seems like it will accomplish that. So thank you for your work on it.
Thank you, Judge Young, but I completely agree. And if there's no other concern with 9.3A, just to make sure we cover everything, there was also edits done to 1-3. Does anyone have any concern or thoughts about the edits to 1-3 in the commentary?
Jack Steigelfest. I have just a grammatical question. I'm sorry to raise it, but the first sentence of the commentary to section A, where it says the assertion of a privilege is a preliminary question. Does it mean the application of a privilege? I don't know that the assertion of a privilege is the question being determined.
Yeah, I don't know where that language came from, Jack. You know, I mean, it certainly has been there for a while, which is not a defense, not a well, sometimes it works actually as a grammatical defense, but I don't know if Judge Prescott, if you have any thoughts, whether that's in the federal rule or what.
I think it was in our original version, but I agree with Jack that perhaps the word applicability would be better than assertion, just from a logical standpoint.
Three points, Jack.
You got to be careful with that, Jack, because you could end up being responsible for correcting the grammar and usage in the entire rules of evidence, which could be a life sentence.
Or at least until the end of my tenure. So that's a small change that I don't think anyone really objects to and might make it more readable. So we could certainly make that. Anyone else have any thoughts or concerns or ideas about 1-3? Okay. And seeing none, we have 1-1, which was a smaller change. But if anyone has a thought about it, we should discuss it and get it on the table. Okay. So it looks like we are in pretty much agreement, unanimous agreement on the changes. I have to really reiterate that our thanks to the working group for undertaking this task. It was certainly an undertaking, and we appreciate all your hard work in making this at least clearer to me, hopefully to everyone else, and maybe useful for the bench and bar.
Justice Mullins,
I'm sorry to interrupt you.
Sure.
Did you want to take a formal motion and vote on 1-1 and 1-3, or do you want to defer a formal vote until the next meeting where the redraft of 9-3A is presented?
My thought was to wait until the final version is in front of us. And I think that will be at the next meeting. And I don't think we're going to lose much time unless a different pandemic hits. I'm hoping we can do this again, the same platform in January.
Okay, great.
So yeah, I think we can do that in the final form next time. we have a meeting. With respect to moving down the agenda, 3C, that's 1916, the Public Act. As I mentioned earlier, I'm going to put that off until our next meeting as well. So our next meeting will be able to approve 1-3, 1-1, and 9-3A, and then hopefully come to some resolution on 1916 and what we're going to do, if that's going to be included in the code or not, and how it will look if we include it in the code. So with that, if there's any other business, I don't have any, but if there's anything any of you want to bring up, this would be the time we could do it. Okay, if there's no other business, then before we adjourn, I would again say thank you to everyone to focusing on these issues, and the working group. Again, we really appreciate all your hard work. If there's nothing else, is there a motion to adjourn?
Sure.
Motion
So
to adjourn.
moved. It's Karen Goodrow.
Second?
Mike Gaylor, I'll second it.
Thought you all wanted to stay. Okay. Then we are adjourned. You guys should hear from me hopefully within I don't want to have a meeting right around the holiday, so maybe early January, and hope